Machine guns. What is going on with them legally, both in the past, the present, and the future? In this video, we're going to be covering all of that so you understand exactly where machine guns fall, and then we're going to be breaking out the crystal ball game to make some educated guesses. So guys, let's get into it. Machine guns. First invented in 1884 by Hiram Maxim, a machine gun allowed a firearm to fire more than one shot per function of the trigger. Per function of the trigger. That's being litigated right now as I'm filming this. No, we're not talking about AR-15s and other modern sporting rifles. We are talking about actual machine guns. Not the ones that your cousin who knows nothing about guns claims to be a machine gun. Just because something may look like a machine gun does not mean that it actually is a machine gun on the inside. Like a person, it's in the heart. That's what matters. Except for machine guns, we're talking about how the trigger works. Again, more than one shot per function of the trigger. That's what the federal law says. Now, basically all machine guns were lawful for just about anyone in the United States to purchase without regulation until the National Firearms Act in 1934. Now, this isn't a video about the NFA or the National Firearms Act, so I'm going to cut myself off because when I was doing my notes for all this, it basically turned into a whole NFA video, which then just turned into me working on an NFA video. So if you want me to finish that video, let me know in the comment field below and stay tuned because I'm sure that will be coming out in the not too distant future. But for right now, we're talking about machine guns, so we're pressing on. So what you need to know is that machine guns were first regulated, as I was saying, in 1934. And prior to that, you could effectively order them through a catalog in the mail right to your front door. Now, after the NFA was passed, you had to pay a $200 tax stamp and get permission to lawfully be in possession. Again, that's the low resolution version. This all meant that machine guns made today at a factory could be sold to you tomorrow. Or you could also conceivably build your own in your basement or modify your gun, again, provided you got the right forms and permission slips and all that other kind of stuff so that it fired more than one shot per function of the trigger. Now, this all sounds great. Unfortunately, this party ended during the negotiations for the Firearm Owners Protection Act, sometimes awkwardly referred to as FOPA. FOPA was passed in 1986 when then Democratic Senator William Hughes basically inserted what became known as the Hughes Amendment in order to assist Republicans with passing the Firearm Owners Protection Act. And this effectively banned any newly manufactured machine guns on or after May 19th, 1986 from being able to enter the civilian market. So those machine guns that were already in civilian market existence were allowed to stay and were effectively grandfathered in. And most people in most states can still legally purchase those same existing machine guns that were properly registered prior to 1986. Notably, and listen up if you're new here, lawful machine guns since the NFA have never been used to commit a crime by anyone who wasn't wearing a badge. So riddle me this, if guns somehow cause crime and the more dangerous the gun somehow makes that crime both more likely and much worse, why does that statistic exist? And no, it's not because there are only 5 of them and they're locked away in some sort of Indiana Jones Raiders of the Lost Ark style warehouse. As of 2016, there were an estimated over 175,000 machine guns in civilian possession across the United States. Over 175,000. That number is dropping, however, at an estimated rate of about 600 per year. Why? If you want to know more about that, then check out my video with Mike Kwiatkowski where we did a deep dive on that subject, hopefully appearing in a card above my head right now. Otherwise, always link in the description box below as well. Okay, so that's a quick background about machine guns, what they are, where they came from. What's the legal outlook for the future? Well, ever since what I call them, the holy trinity of U.S. Supreme Court firearm cases started to hit, starting with Heller in 2008, which then turned into McDonald in 2010, and finally in 2022, culminating with the Bruen, B-R-U-E-N, for those of you on your lawnmower decision. This basically served to resurrect the Second Amendment from being a second-class right to one that now finally has gotten the legal love and attention that it deserves. But the question remains, what's next? Particularly for us, for purposes of this video, what's next for machine guns? Will the regulations that govern and restrict machine guns, such as the National Firearms Act and so forth, are they going to be struck down? Let's take a look. So first we need to understand, what are the legal goalposts? In other words, what are both the pro-gun and anti-gun sides trying to do? What do they need to do in court in order to win the legal fight over the future of machine guns? Well, the legal goalposts are this. Bearable arms that are in common use today are presumptively protected by the Second Amendment. Period. Full stop. If you need to run that back, press pause, rewind 10 seconds. Subsequent decisions, such as the Bruen decision, explicitly blessed semi-automatic handguns as being in common use. So common use, semi-automatic handguns definitely in. The U.S. Supreme Court, in another decision called Catano in 2016, also said that electronic weapons were in common use when rejecting the argument, among others, that we're going to circle back to, that the Second Amendment somehow only applied to weapons that were in existence at the founding of the Second Amendment. Not the way it works. From that decision, quote, the court has held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Now, prima facie is a fancy Latin way of saying on its face, or in other words, presumptively or likely protect. So in other words, the Second Amendment applies to all bearable arms in common use today, unless they fit an exception. So what are the exceptions? Well, it might depend on who you ask. This is what I mean. Proponents of civilian disarmament take a passage from the Bruen decision in 2022 that says this, quote, while the historical analogies here and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach, end quote. Guys, thanks for checking out this video. I've kind of gotten away from doing these deep historical dives because frankly, I don't know if people like them as much. So if you do enjoy this, let me know by hitting that like button, dropping a comment down below. I've got all sorts of things in the works to be getting into. Deep dives on what's the militia in the Second Amendment, dangerous and unusual weapons, statute of Northampton, to name some of many others on the board. But if no one wants it, I can just keep the information up here too. So let me know. We appreciate you sticking around. And now back to the video. Now, victim disarmament enthusiasts, that's one of my buzzwords for gun control advocates. Victim disarmament enthusiasts take this passage, specifically the second part, which says dramatic technological changes requiring a more nuanced approach, to mean that more or less everything since 1789 is not protected under the common use test, since semi-automatics, detachable magazines, even revolvers, among virtually everything else, were not in existence then and represent, therefore, a dramatic technological leap forward. Now, while they have an obvious point, their reasoning is deeply flawed and contradictory. Let me quickly show you why. If they are right, then the common use test would work one of two ways. First, what firearms were in common use in 1789, or second, what firearms from 1789 are in common use today. That would seem, following their logic, to be the only two ways that the U.S. Supreme Court could have intended the common use test to work. Now, the first one is irrelevant, since we have never, as a society or as a culture of laws, conditioned a right based upon what technology was around at the time that the right was recognized. Not started, but recognized. Don't believe me? Do you think that the right to free speech only applies to liberty poles, paper leaflets, and books in the town square? Does it not also apply to the internet, computers, broadcast television, radio, and virtually everything that has come our way since 1789? Does the freedom of religion not extend to any religion that was not in existence at the time of 1789? Does the Fourth Amendment not apply to cars or your phones since, hey, those weren't around to be searched back in 1789? Of course not. And all of those amendments, by the way, were also introduced in 1789 at the same time, place, and manner as the Second Amendment. So what's good for the goose must be good for the gander, right? Now, the second way of interpreting that statement is also ridiculous, namely firearms from 1789 that are in common use today. By the way, the answer to that question is basically zero. So basically both ways that the gun control crowd want to interpret and frankly abuse that phrase from the Bruen decision, you end up in ridiculous positions that more than nullify the test in its entirety. So how do we apply this test? Well, we can read what the Supreme Court has themselves said in how to apply the common use test. Quote, "Some have made the argument bordering on the frivolous that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way," end quote. That's not Tom Grieve speaking. That's the U.S. Supreme Court speaking. Bordering on the frivolous. Good thing to remember. Of course, they went on to say, quote, "The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding," end quote. So hopefully we have now established that the question is, what is in common use today? Fine. Are there any other exceptions, though? Yeah, there's one. The Supreme Court also wrote in that 2008 Heller decision, quote, "We also recognize another important limitation on the right to keep and bear arms. Miller said," Miller's another case, "as we have explained, that the sorts of weapons protected were those in common use at the time. We think that limitation is fairly supported by historical tradition of prohibiting the carrying of dangerous and unusual weapons," end quote. Then a bit later, Heller went on to write, quote, "We therefore read Miller to say that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barrel shotguns," end quote. So dangerous and unusual weapons. That's what the Supreme Court had in mind when they said the Second Amendment applies prima facie to all bearable arms in common use today. Don't blame me. I'm just the messenger. But what is a dangerous and unusual weapon? Here's where we'll start to see how I think the court will rule on machine guns if they get a chance. Here's where we start to get to the crystal ball part, because you can't help unpack the answer to that question without starting to get clues about what the court might do if they ever get a chance in the future. And keep in mind, our Supreme Court as of 2024 is likely as pro-gun as it will ever get. So what the current court has recently ruled on their interpretations and understanding of the Second Amendment may well represent the high water mark for our Second Amendment rights. And no, I do not enjoy saying that. I'm just being a realist. There you go. Now, this is usually the part where people start bringing up the 1939 Supreme Court case called Miller, which you heard me reference Heller describing a couple moments ago. Miller was a weird case in a lot of different ways that dealt with a legal challenge from a gangster to the National Firearms Act of 1934. So Miller was arrested and charged for being in possession of an SBS, a short-barrel shotgun, without paying the proper tax. Now, oddly enough, when the case made it to the Supreme Court, Miller was dead, and there was no one to argue there on his behalf, or maybe more accurately, on behalf of the Second Amendment. So what happened was one of those classic one-sided beatdowns where only the government in support of the NFA was arguing, and who was listening to them was, of course, a Supreme Court that was recently judge-packed by Franklin Delano Roosevelt in the 1930s. Now, I'm going to skip ahead to how Heller and Bruen interpret Miller, since that's the important part for this video. If you want to see me unpack Miller more, let me know in the comment section. I'm not arguing about what I think Miller ought to mean. Just understand this. It's understandably very easy to read Miller and walk away thinking that the Second Amendment may actually only protect military weapons in military use. In other words, may be illegal to own your duck shotgun, but you can get that M16. Now, I'm going to let the court do the rest of the talking from Heller. Quote, "We may as well consider at this point, for we will have to consider eventually, what types of weapons Miller permits. Read in isolation, Miller's phrase, part of ordinary military equipment, could mean that only those weapons useful in warfare are protected. That would be a startling reading of the opinion, since it would mean that the National Firearms Act's restrictions on machine guns, not challenged in Miller, might be unconstitutional, machine guns being useful in warfare in 1939. We think that Miller's ordinary military equipment language must be read in tandem with what comes after. Quote, ordinarily when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of a kind in common use at the time. The traditional militia was formed from a pool of men bringing arms in common use at the time for lawful purposes like self-defense. In the colonial and Revolutionary War era, small arms weapons used by militiamen and weapons used in defense of person and home were one and the same, end quote. Let me say it for you. Without the National Firearms Act, likely just about every single one of the more than 20 million modern sporting rifles like AR-15s would probably be full automatic in one flavor or another, whether burst fire, whatever it is you want to call it, all right? And therefore, they would have to be in common use. So how can you use an in common use test to decide whether a firearm that has been illegal to manufacture for civilians since 1986 and since 1934 to own without a de facto licensing and tax fair? If I invented a new whiz-bang way of making firearms go bang, that is objectively better than any other system that we have out there. It's not striker fired, it's not hammer fired, it's something completely different that has incredible, undeniable advantages to performance, reliability, cost, ease of cleaning, you name it. One would think that with enough time, it would take over the marketplace, or at least it would become mainstream, right? Well, what if the government banned it first? My design in the firearms would never actually live up to the common use test because the government basically snuffed them out in their infancy. Now, that might be an unstoppable tactic that the courts weren't thinking about, but just the same, that is a loophole that stands today, and that might be the crux of the issue when it comes to machine guns and the NFA. And that's likely going to be the best argument that machine guns have going for them because, as you can tell, from what the court has said in Heller, they may have had machine guns in mind when they said that they were dangerous and unusual weapons and that such weapons could be restricted. And by the way, federal circuit courts since Heller have all rejected arguments, if they've heard them, that machine guns are in common use today by law-abiding citizens for lawful purposes and have basically found them to be dangerous and unusual. I found cases in the 3rd Circuit, 5th Circuit, 6th Circuit, and 8th Circuit that have all upheld this view that machine guns are dangerous and unusual, non-common use by law-abiding citizens, with none to the contrary. For those of you who are not new here, the 5th Circuit being perhaps, at least by outcome, by far the most pro-Second Amendment circuit in the country, if even the 5th won't go there, you know machine guns are in trouble. Now, we recently did a video, by the way, also adding to the fact that there might be an upcoming challenge to the 9th Circuit, but I doubt that that's going to change anything. I also found about a half dozen or so examples of federal trial courts that also marched in lockstep with this view. See a full list if you want in the description box below. But where did the dangerous and unusual language come from? The court didn't just invent it. Now, that's going to have to wait for another video because that history actually goes all the way back to 1328 and the Statute of Northampton. If you want to see that, let me know in the comments since I've held off on videos like this and like that one because frankly, I don't even know if a lot of people like this kind of stuff. So if you're out there, let me know. I will also say that if you followed the oral arguments during the bump stock case that we've covered extensively on this channel, you may also know that not one of the judges were exactly racing the defense of machine guns as being constitutionally good to go. They were all, at best, silent on this point, or basically considered it safe ground to say that machine guns are dangerous and unusual. Again, can you hear the nails in the coffin? Lastly, it's also worth mentioning that there could be another attack for machine guns against the National Firearms Act in a case called Murdoch versus Pennsylvania. This was a Supreme Court case going back to 1943. Fact check me in the comment section if I get that wrong. The gist of the case is that there was an ordinance that required door-to-door salespeople to get a license if they're going to be going door-to-door to sell stuff. And some folks tried to apply this to some Jehovah's Witnesses who were handing out pamphlets and proselytizing. Basically, they were practicing their faith. And the argument came up as to whether or not this law was constitutional, and the court said no, it's an unconstitutional tax on religious exercise. So let's skip that ahead a bit. It's an unconstitutional tax on a core fundamental right, similar to, for instance, like a poll tax or something like that. So the question is, could this be struck down? Could the National Firearms Act, as it applied to machine guns or whatever else for that matter, SBRs, SBSs, silencers, you name it, be struck down because we're literally taxing a constitutional right? My answer to that is, let's just be real. Even if the court were to rule this way and they were to free machine guns from the $200 tax, do you really think that there won't be a similar or worse replacement law coming? And don't forget, that may not change, of course, the Hughes Amendment either, but I understand incrementalism one piece at a time. I, for one, certainly don't have a lot of hope in looking through all the different oral arguments, what courts have been doing, and so forth, and frankly, the lack of political appetite out there. I don't see either party jumping on the steamship of we need to run in the platform of free machine guns. In the end, being realistic, I just don't have a rosy outlook for what I think the legal future of machine guns may be, despite their unblemished record of safety on the registry. Thanks for making it this long in the video. Our quote of the day comes from Plato. He who does not desire power is fit to hold it. And hopefully if you like videos like this, you'll let me know in the comment section below, as well as by hitting that like button. We appreciate you sticking along to the end, and we'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.